Department of Homeland Security to answer questions raised yesterday and today related to immigration issues, asylum seekers, refugees, and non-citizens broadly.
Thank you. Madam Country Rapporteur, Mr. Guisset, Mr. Coote, and distinguished members of the committee, thank you for this opportunity and for your questions regarding how the state is ensuring accountability specifically for any use of force by Customs and Border Protection. I will share with you the specific protections and accountability CBP has in place for the use of force by its officers, including training and accountability through publication of data. I will also speak to the questions raised regarding the status of Title 42, including its application to minority populations, as well as the latest status of the migrant protection protocols. I will then turn to my colleague, Mr. Mina, who will speak in further detail to department oversight of these matters, as well as other immigration questions you raised. Our Department of Homeland Security enforces strict standards of conduct that apply to all of its employees, including CBP, whether they are on or off duty, investigates deaths resulting from use of force, and the department regularly follows up on both civil rights and civil liberties related complaints. Regarding these standards of conduct, in September 2018, our department issued a department-wide use of force policy, which contains standards and guidelines for use of force by DHS law enforcement and affirms the duty of all DHS employees to report improper uses of force. In addition, in 2021, Customs and Border Protection released for our officers an updated use of force administrative guidelines and procedures handbook, both of which are publicly available. That use of force policy, guidelines, and procedure handbooks are based on the constitutional standard of objectively reasonable force, as well as federal case law and applicable Homeland Security and Customs and Border Protection policies. The policy specifically states that respect for human life and the safety of the communities we serve, as well as CBP's officers and agents, is paramount and shall guide all employees in the performance of their duties. The updates and changes in the use of force policy and the administrative guidelines and procedures handbook include training on de-escalation, the duty to intervene to stop, prevent, or stop a perceived use of excessive force by another officer or agent, and makes it clear that agents should, whenever possible, avoid placing themselves in circumstances where they have no other choice but to use deadly force. Regarding specific training, we have a Law Enforcement Safety and Compliance Directorate, which develops use of force policy, maintains the appropriate controls and standards, and supplies the highest quality use of force education and training, weapons, and other officer safety equipment. Specific training examples include the following. CBP has installed virtual use of force training simulator systems across the country for our officers. These systems provide CBP officers and agents a realistic and familiar environment for honing and demonstrating necessary judgment, tactics, and skill sets involved in everyday operations. In addition, basic training for CBP Border Patrol agents includes an enhanced use of force scenario-based training experience, emphasizing de-escalation techniques while maintaining border security and agent safety. Border fence training venues have also been constructed and incorporated into that basic training. Regarding accountability, all incidents involving use of less lethal force are reviewed by local use of force review boards, which are comprised of senior management, CBP officials in regional locations across the country. Further, Customs and Border Protection's National Use of Force Review Board is a committee specifically established to review all significant use of force incidents, defined as those that result in serious bodily injury or death, and those that involve the discharge of a firearm, regardless of the outcome. The board is comprised of senior officials from across Customs and Border Protection, as well as officials from Homeland Security and our Department of Justice colleagues. Both these boards review use of force incidents in order to determine if the use of force was consistent with Customs and Border Protection policy, and to determine if there are issues warranting referral to the CBP Office of Professional Responsibility for further investigations, and finally, to assess any issues involving training, tactics, equipment, or policy. As of May 2022, There have been 21 meetings of that National Use of Force Review Board that have reviewed 66 significant use of force incidents. External to CBP accountability and remedies for excessive use of force are also addressed by our DHS Office of Inspector General, or OIG. That office receives information about all allegations of excessive use of force involving DHS employees, contractors, and programs. The investigations may result in criminal prosecutions, fines, civil monetary penalties, administrative sanctions, and personnel actions. Our Office of Inspector General also maintains a 24-hour complaint hotline specifically for this purpose. And if our Inspector General declines to investigate, our own Office of Professional Responsibility, special agents, fact finders, or management may also investigate. In addition, our DHS Office of Civil Rights and Civil Liberties, or CRCL, also investigates complaints alleging excessive use of force by Customs and Border Protection personnel. My colleague, Mr. Mina, will subsequently speak to those investigations on each of these topics. Finally, Madam Country Rapporteur, Mr. Diabe, and distinguished members, regarding the questions on statistics, I will note that from 2017 onward, Customs and Border Protection has begun tracking and publicly reporting assaults and use of force through an online dashboard. Specifically, those use of force statistics can be separated by type, less lethal, vehicle, vessel, and firearm, and other. According to that dashboard, the number of use of force incidents for fiscal year 2019 was 592. Fiscal year 20 was 610. Fiscal year 21 was 768. And fiscal year 22 has had 629 incidents as of the end of June 2022. Next, Mr. Guisset and distinguished members, regarding your questions as to the status of Title 42 and application to minority populations. I want to emphasize DHS takes allegations of disparate treatment very seriously and seeks to ensure equity in its immigration policies. Concerning Title 42, on April 1st, 2022, the CDC announced the termination of its Title 42 public health order issued first in March 2020, with the termination to be implemented on May 23rd of this year, to provide us time to institute the protocols and prepare for resumption of Title 8 immigration processing. As implemented, of course, by DHS since March 2020, these public health orders had required expulsion of certain single adults and family units arriving at the land borders. However, subsequent to this decision in April by our Center for Disease Control, on May 20th, 2022, a federal judge in a United States District Court issued a preliminary injunction enjoining our planned termination of Title 42. Our government has appealed this injunction, and litigation is ongoing. However, this litigation in our federal court system requires the U.S. government to maintain operating under the Title 42 public health order until that litigation is resolved and the Title 42 order is no longer in place. Once the Title 42 order is no longer in place, DHS will process individuals encountered at the border pursuant to the standing provisions of the United States Immigration and Nationality Act, as contained in Title 8 of our U.S. law. Concerning screening and exceptions to Title 42, while the Title 42 order remains in effect, those individuals subject to the order who express a fear of the country to which they would be expelled are screened to determine if it is more likely than not that they would be persecuted or tortured in the places to which they would be expelled. In accordance with another court case, non-citizens who are part of a family unit and who have manifested a fear of returning or being sent to the country to which they would be expelled are accepted from the CDC order of Title 42. In addition, individuals can be accepted from Title 42 based on case-by-case determinations made by CBP officers for certain reasons, including humanitarian grounds. As an example, Haitians have been granted humanitarian exceptions from Title 42 on that case-by-case basis. I do also want to note specific efforts, as there have been questions, DHS has undertaken to specifically assist Haitian migrants. First, on May 22nd, 2021, the Secretary of Homeland Security, Mayorkas, announced a new temporary protected status designation for Haiti for 18 months for those Haitians who are residing in the United States. DHS has also made efforts to provide legal pathways for Haitian migrants. On March 31st, 2022, DHS and the Department of Labor announced a supplemental allotment of 11,500 H-2B visas for nationals of Haiti and several other countries. The H-2B program permits employers to temporarily hire non-citizens to perform non-agricultural labor or services in the United States. And on June 10th, 2022, DHS also announced it is working with the Department of State to resume processing under the Haitian Family Reunification Program. This parole program allows eligible Haitians to enter the U.S. and reunite with U.S. citizens and lawful permanent resident family members while awaiting processing of their immigrant visa. Our goal is to resume this process in the next several months. Finally, Mr. Guisset, I will now address your question of yesterday regarding the status of the migrant protection protocols. As you noted in your question yesterday, on June 30th, our U.S. Supreme Court held that the Biden administration's decision to terminate the migrant protection protocols did not violate federal immigration law, and that the Department of Homeland Security's memorandum ending the program was a final agency action. On August 2nd, the government filed a motion with our Fifth Circuit Court of Appeals requesting the circuit remand to the district court, and in our process, the Fifth Circuit did so this week on Monday, August 8th. The U.S. Northern District of Texas District Court vacated its previous injunction. Our department welcomes the U.S. District Court's decision, which follows the U.S. Supreme Court's June 30th decision to lift the injunction that required us to re-implement MPP. As our Homeland Security Secretary Mayorkas has said, MPP has endemic flaws, imposes unjustifiable human costs, and pulls resources and personnel away from other priority efforts to secure our border. With that decision of this week, Homeland Security, in consultation with the Department of Justice, is committed to ending the court-ordered implementation of MPP in a quick and orderly manner. Individuals are no longer being newly enrolled into MPP, and individuals currently MPP in Mexico will be disenrolled when they return for the next scheduled court date. Those disenrolled then will therefore continue removal proceedings in the United States. Thank you again for this opportunity to come before this committee. I will now turn to my colleague, Mr. Mina, regarding broader department oversight on each of these points and other questions related on immigration and DHS specific matters. Thank you.
Good afternoon. As referenced by my colleague, Mr. McCammett, the Department of Homeland Security enforces strict standards of conduct that apply to all of its employees, whether on or off duty, and investigates deaths resulting from use of force and follows up on civil rights and civil liberties complaints in all public-facing department activities. My office, the Office for Civil Rights and Civil Liberties, is a key partner in implementing this oversight framework. The Office for Civil Rights and Civil Liberties, or CRCL, investigates complaints alleging excessive use of force by Customs and Border Protection personnel. CRCL investigations focus on potential policy and procedure concerns related to the use of force by CBP. Where concerns are identified and recommendations are made, CRCL works with Customs and Border Protection to address the concerns and mitigate potential civil rights and civil liberties issues related to policies, directives, and encounters to ensure actions are consistent with best practices and DHS department policy. Similarly, CRCL also investigates use of force allegations made against U.S. Immigration and Customs Enforcement, or ICE, including claims by migrants from Cameroon and other Black migrants. CRCL receives notification of all non-employee deaths that occur in CBP and ICE custody, as well as deaths involving use of force by law enforcement officials. Upon notification of a death, CRCL requests relevant records and information from Customs and Border Protection and U.S. Immigration and Customs Enforcement, which are then reviewed to determine whether a more detailed investigation is warranted. If so, an investigation is then conducted. As with all complaint investigations, if issues of concern are found, recommendations are made directly to CBP and ICE leadership. And more recently, the Law Enforcement Coordinating Council referenced yesterday is also focusing on updating use of force policies and training across the Department of Homeland Security. As a follow-up to points made by Mr. McCammett regarding the migrant protection protocols in Title 42, my office, the Office of Civil Rights and Civil Liberties, has been reviewing the effect of these policies on the most vulnerable, including Black migrants, who faced heightened risks throughout the migration journey. CRCL recently conducted virtual and in-person visits to the border to observe migrant protection protocol processing. The office heard from migrants themselves and non-governmental organizations provided legal and social services on both sides of the border. CRCL used its observations to provide proactive policy advice to the department to help improve implementation of the migrant protection protocols while it has been in place. With regard to Title 42, CRCL received several complaints that screenings did not consistently occur for all individuals who expressed a fear of torture. Non-governmental organizations had expressed concern, in particular about the expulsion of LGBTQI plus individuals who are particularly vulnerable to violence in Mexico. CRCL issued recommendations to Customs and Border Protection pursuant to a complaint investigation regarding medical care and humanitarian protections for persons subjected to expulsion under Title 42. Member Guisset, I'd like to address, and distinguished members of the committee, I'd now like to address the topic of family separation, as raised yesterday. In an effort to reunite children separated from their families at the United States-Mexico border between January 17th, 2017 and January 20th, 2021 during the previous administration's zero tolerance policy, President Biden signed Executive Order 14011 on February 2nd, 2021. In that executive order, the president vowed to protect family unity and established an interagency task force on the reunification of families, which regularly reports to the president on its progress. Overall, and through the support of NGOs, more than 2,000 children have now been reunited with their parents in the U.S. As of July 28, 2022, the task force itself had facilitated the reunification of 400 children and parents who were previously separated at the U.S.-Mexico border through the use of the zero tolerance policy and related initiatives. The task force launched Together.gov and Juntos.gov as a mechanism for separated families to register for reunification and/or support services. The task force continues to identify and implement long-term reform efforts to ensure that family separations do not occur, except when clearly necessary for the safety and well-being of the child or as required by law. Again, my office has been working with the task force to promote the principle of family unity in DHS immigration policies and programs. I'd now like to turn to the question of statelessness, again raised by Mr. Guisset yesterday. The United States has championed global efforts to end statelessness and recently committed to improving protection for stateless persons in the United States. In support of the UNHCR I Belong campaign to end statelessness, the U.S. government seeks to improve identification and documentation of stateless persons, data on stateless populations, and access to basic services and protection for all stateless persons, including a path to citizenship. In particular, U.S. Citizenship and Immigration Services, a component of the Department of Homeland Security, concluded 2 technical sessions with the UNHCR on building a process for making statelessness determinations. At a UNHCR high-level officials meeting in December of 2021, the U.S. Department of Homeland Security took a significant step by pledging to adopt the definition of statelessness for U.S. immigration purposes and to establish a statelessness determination procedure, among other efforts. Through the adoption of a standardized definition of statelessness, the United States will ensure it can recognize unique barriers encountered by stateless persons and better identify and protect such individuals. Although the United States has not acceded to the statelessness conventions due to certain provisions that would require changes to U.S. law to comply with, we nevertheless strongly support the objectives of both conventions. U.S. law does not generally treat stateless persons differently from other non-citizens, and the United States does not contribute to the problem of statelessness. U.S. Citizenship and Immigration Services has made a request to the Intergovernmental Consultations on Migration, Asylum, and Refugees for best practices on building a process for making stateless determinations and received feedback from over a dozen countries. And I'd now like to turn it over to my colleague, Ms. Trickler-McNulty, who will cover other immigration-related topics.
Thank you. And along with my colleagues, I would like to thank the committee for the chance to respond to some of the questions. First, I do want to address the specific data request from Mr. Guisset for race and ethnicity data related to the use of immigration detention. Unfortunately, the Department of Homeland Security and Immigration and Customs Enforcement do not collect this specific information. However, we can provide nationality data for the last 5 years for individuals held in immigration detention, and we'll forward that to you for your review. Next, I will discuss the questions related to mandatory detention and asylum seekers. Since World War II, more refugees have found permanent homes in the United States than in any other country, more than 3 million in the last 40 years. Welcoming refugees is central to our nation's identity, and providing a home for refugees is a central part of our international humanitarian programs. United States immigration law implements obligations under the 1967 Protocol relating to the status of refugees, to which the United States is a party. U.S. immigration law also provides additional protections and relief for refugees and asylum seekers. U.S. domestic immigration laws generally require certain categories of non-citizens to be detained pending their immigration proceedings. Among these categories are, first, certain inadmissible non-citizens who arrive or illegally cross the border and were processed for expedited removal, and secondly, non-citizens who are inadmissible or deportable for having committed certain criminal offenses, or those subjected to terrorism-related grounds of inadmissibility, pending a decision on whether the non-citizen is to be removed from the United States. For non-citizens subject to mandatory detention, the Department of Homeland Security has discretion to authorize release while removal proceedings are pending, and with some exceptions, detained non-citizens in removal proceedings have the right to a custody redetermination hearing before an immigration judge. Individuals who arrive at a port of entry and are processed for expedited removal and receive a positive credible fear determination are automatically considered for parole, and a majority of these individuals are released from immigration detention on parole. Regarding the length of detention, the median completion time for credible fear, reasonable fear, and status reviews before an immigration judge was 6 days in the first quarter of 2022. I would also like to reference 3 newer policies that relate to remarks of committee members yesterday and today. First, in March 2022, the Department of Homeland Security published the Asylum Officer Rule as an interim final rule, and phased implementation of this new rule began in May of 2022. Under this interim rule, non-citizens who receive a positive credible fear determination can be released from custody and have their asylum claims considered by a U.S. Citizenship and Immigration Services asylum officer in a new asylum merits interview. If the asylum officer finds the individual eligible for asylum, the individual will receive a grant letter informing them of the applicable benefits and related procedures. If the asylum officer determines the non-citizen is not eligible for asylum, the asylum officer will assess whether the non-citizen is eligible for withholding of removal or deferral of removal, and will issue a notice to appear and place the non-citizen into streamlined removal proceedings before an immigration judge. Second important policy was released in 2021 by Immigration and Customs Enforcement. It was a new directive to support non-citizen victims of crime. The directive commits to using a victim-centered approach and to assist victims in accordance with the Violence Against Women Act and the Trafficking Victims Protection Act. Under the new directive, Immigration and Customs Enforcement will exercise prosecutorial discretion in appropriate circumstances to facilitate access to justice and victim-based immigration benefits for non-citizen crime victims. This policy is intended to minimize any chilling effect that civil immigration enforcement actions have on the willingness and ability of non-citizen crime victims to contact law enforcement, participate in investigations and protections, pursue justice, and seek immigration benefits. The third new policy relates to deaths in immigration and customs enforcement, detention, or custody. Under the revised policy, all deaths in custody are subject to the same protocols, and the newest version of this policy allows the Director of Immigration and Customs Enforcement to request the same level of review for individuals who die shortly after leaving custody to address any concerns in their treatment. For each death, there is a medical review to determine whether the detained individual received appropriate health care under nationally recognized standards of detention health care practices. Additionally, the Office of Professional Responsibility will conduct an objective examination of the individual's entire time in immigration detention and the facts and circumstances surrounding their death to determine whether or not the relevant detention standards were complied with, and to identify any areas of concern regarding the individual's care and custody. Both of these reports are provided to Immigration and Customs Enforcement Senior Management and the Office for Civil Rights and Civil Liberties. Immigration and Customs Enforcement also strives for transparency in this process, and upon the official report of a detainee death, notifications will be made to Congress, national non-government organizations, and the media. And the news release and information with details about the death are published on the public website.
very much. Thank you. I am cognizant of time, and we have several more issues to cover, so I apologize for cutting you off, but I do want to be respectful of our time with the committee. So I'm going to turn it over to our colleagues from the Department of the Interior to address the various questions related to Indigenous communities.